I have not opened my case excepting by order pattern 27. Order pattern 27 is accepted. Then one.
Let him say, sir, because he needs to.
When the merits of the thicker tenant or not, which is under section 5 is barred. Civil code cannot touch. He is trying to convince my lord that
So
the
he is
structure is
against-
there.
He is trying to explain, I believe, the appellate court's appellate court's.
He is saying that I
contention.
cannot be a thicker tenant because of the ABCD reason. It is a 12 years. I have not constructed.
15 years.
That point, my lord, under the 2000 new act is barred. Civil court cannot touch that issue.
That is not the settled provisional law. Supreme Court has clarified.
Yes.
High Court also.
Can you see one?
I have referred. I have given thicker tenancy act.
So this is. Oh, sorry, one. Can you see 5.3? Section 5, subsection 3.
Unless this document is admitted to evidence, Section 5.3 will not come into play.
No argument can be advanced in a civil court regarding the thicker tenancy.
Did you raise the point of your being a thicker tenant?
Entire judgment, my lord has perused. If your lordship peruse, my lord find entire judgment is based on thicker tenancy.
Because
My first submission is this point cannot be agitated before the court. Can it take I have not argued on merit on that ground only. Either your lordship will accept my order for 27. If it is accepted, then in view of the judgment of the apex court, the suit cannot be proceeded.
therefore, question of acceptance is there.
That's this
So I
is my
have to
only
satisfy
submission.
your lordship by placing
But
the.
he cannot go on saying
What
that
was-
the order of thicker tenant is bad. That is not the forum. That I am submitting. If you want to challenge that order, this order I have handed over to my lord. He has
absolutely bad.
absolutely bad.
Non-subject
I
notice
accept
upon
it.
me.
Accepting.
That order cannot be binding upon me.
Can my lord?
So why
Because
did
no notice was served upon us.
Can my lord touch that? This submission?
Yes.
Yes.
you were not aware of this
No,
Thuka
no
controller's
notice.
order?
Nothing. No notice. Even they are saying.
Problem.
Authority concerned.
I
They are
say
saying
it is expert.
in absence of counter claim, we are recording the name. In absence of counter claim, that is their finding. How the counter claim can be filed by the adversary when no notice was served upon the person affected? No notice.
I say it is
If
illegal
any
order.
notice, if he notice
It's
is
illegal
served,
order. Forum is elected.
forum is court can take into cognizance.
Bar.
This
5-3.
document cannot be taken into consideration. I
So
shall
you
show.
filed the second appeal in the year 2015,
Filed.
right? At that point of time, this issue was not there,
Crystallized. Not crystallized. The proceeding was going on.
but that was also not mentioned before the trial
Kindly
court.
peruse the judgment. May I praise?
Because as
My lord knows issue may not be framed if the parties are kindly come to the trial court judgment. Kindly come to the trial court judgment.
Nothing has been disclosed before the appeal court in course of evidence.
Kindly come to page 24. Whatever I have marked, but I want to show to your lordship. The petitioner stroke respondent has asserted that the lesser gas created leasehold right only with respect to the land of the schedule of the said lease deed for 5 years. It has been emphatically submitted that on the date of execution and registration of the lease deeds, the Calcutta Thicker Tenancy Act was very much in force, and in view of section 10, which runs that notwithstanding anything to the contrary contained in act on the determination of the interest of the thicker tenant in land comprised in holding as a result of ejectment from the holding or of a surrender of abandonment of the holding by the thicker tenant or otherwise any structure standing thereon. Such land existing on the date of such deliberation shall vest to the landlord. So Thicker Tenancy Act was very much consideration of the court. Then my lord kindly turn over. Yes.
so let us hear both together. I mean, this appeal and order 41 rule 27, it will be considered.
No, if my lord is
I need to know the background.
certainly,
Without that, all of a sudden, this Thicker controllers.
I want to show to your lordship
Hmm.
that this order is today surfaced. This order was not there, so I am not late of approaching your lordship's court in second appeal. The moment the order was passed by the Tika controller, I bring it to notice of the court.
Fair enough. So
I am
that
not
will be
late.
considered
Now, you
at the
have
time.
to consider what is the effect of that. But I want to show to you a judgment.
First of all, let us get into this
But kindly take
subject matter of the appeal, and thereafter,
Yes.
in concurrence,
Subject matter
Order
of the-
41, Rule 27
subject matter of the
application will
appeal
also
is
be considered.
eviction.
Hmm.
From a property. There, my lord, your lordship will find that in the judgment, both the court judgment, effect of thicca tenancy was considered. Now, my lord, this is the judgment I am relying on. 2003 1 Supreme Court cases 7 to 6. Well, kindly come to paragraph 7. Stay there.
Paragraph
7. Normal rule is the right of the parties crystallized on the date of filing of the suit. Now the exception, what is the exception? Having heard the learned counsel for the appellant as also the learned counsel for the state and the private respondent, we are satisfied that the appeal deserves to be allowed. The ordinary rule of litigation is that the rights of the parties stand crystallized on the date of commencement of litigation, and the right to relief should be decided by reference to the date on which the petitioner entered into the portals of the court. Then, a petitioner, though entitled to relief in law, may yet be denied relief in equity because of subsequent or intervening events. That is the event between the commencement of the litigation and the date of decision. The relief to which the petitioner is held entitled may have been rendered redundant by lapse of time or may have been rendered incapable of being granted by change of law. There may be other circumstances which render it inequitable to grant the petitioner any relief over the respondents because of the balance tilting against the petitioner on weighing the inequities pitted against the equities on the date of such and such. This is on writ petition, that's why this one. Ratio of the judgment, as I have understood, that yes, normal course is your right crystallized on the date of filing of the suit, and thereafter it continues. Second appeal is the continuation of proceeding, no doubt about that. In the meantime, intervening facts intervenes. I say if the facts which intervenes is taken into consideration, the suit is not maintainable. Because the land is thicca tenanted land and I am the thicca tenant. If I am the thicca tenant, land is a thicca tenanted land, then my lord, 5.3 is a bar. That is my entire endeavor to show to your lordship this order 4127 application.
So what is your object? What is the date of your affidavit in opposition? Have you filed it?
Enter judgment, my lord, based on this argument of thicca tenancy.
But you should have mentioned before the trial court that you have already.
I should have. My lord knows
You
those
have
like.
not mentioned
My
to
lord
the
knows-
trial court that you
I-
have applied
I
for
accept-
before the TICA
Except
controller.
only I have said I am not governed under this statute. I categorically said that. I am not governed under West Bengal Privacy Tenancy Act. That I have stated. Now, if my lord knows those line of judgment where it says parties knowing the fact issue participate in the proceeding. Thicca tenancy was the issue. Both parties argued on that point. If that is on the every paragraph of the judgment, my lord is fine.
No, yes, sir. What's
Trial court or appellate court disbelieved or disregarded their contention and submission and did not accept. How can it be? How the property can be?
Act second. My lord, if your lordship kindly once look to page 39, I'm reading for my lord. The learned advocate for the respondent has drawn the attention of this court on the cross-examination of DW1, wherein DW1 has stated that we applied before the TICA controller after the commencement of TICA Tenancy Act 1981. (158) page of the paper book, internal page 39 of the judgment. We applied about 5 years ago. I can file documents in this regard, bearing seal and signature of the TICA controller. On that date, I don't know the fate of such application till date. So it was very much with the knowledge of the court.
158?
158. Can we come to last paragraph? Paper book, my lord, is looking 158, last paragraph.
These dog.
So this was this was on
Cross-examination.
11th of May 2007
Yes.
in cross-examination.
Yes.
Yes.
So then you said
So
that
therefore,
it
this application could have been filed by the defendant in the court below. And in the appeal court, nothing. Now, why the statement had been disbelieved by the courts below? Because of execution of deed list for a period of 15 years and in view of section 25 of the Ticket Generation 1949.
Cannot
15
go into
years
that
list,
question.
you cannot.
Court cannot go into that question. That is
Supreme
my
Court
specific case in the
clarified.
appeal.
Supreme Court clarified.
Let's see.
Supreme Court clarified that when a lease period for 15 years, he cannot come within the perimeter of definition of Ticket
Absolutely
Generation.
correct. That has to be challenged before the LRTT. This court, civil court, is denuded of the power.
Unfettered. Civil court has enough power.
Three, one,
Unfettered, unfettered
recall
power.
5-3.
Civil court.
what were the issues framed?
This Thika tenant issue was not framed probably.
What were the issues framed?
In second appeal,
No.
the issue in the court below,
Court below?
page 20. No, 20 no. Yes. It is the instant ejectment case maintainable in its present form. This will cover. The notice to quit valid. Is there existence of relationship of landlord and tenant? This is also covered. Defaulter.
The issue might have been the whether the property is
Now,
Ticket
what
Tenant
was
property
the
or not.
substantial question of law framed?
If had it been this issue, then whether it's Thika tenant or not, on the face of it, this should be stopped there.
Which page substantial question of law?
Yes, 32. That is irrespective. Whether in view of transfer suit property influence respond Devotur character is
That is
lost,
another thing, devotor character. It is
then
already-
become subject to regards to original Ticket Tenancy Act. Landlords could have jurisdiction to decide the question as to
Two.
whether the property is Ticket Tenancy. Now this has to be answered by.
5-3 has been formulated. The civil court cannot touch it. For argument's sake, I accept his contention that this order of the Thika Court is bad.
No, cannot be binding because of non-service of notice. It was your duty to serve notice of the.
I have not tendered my duty. It is subject to challenge in appropriate forum.
Order is
So let
absolutely
us
bad. Why-
concentrate to these two. And along with your Order 41, Rule 27
That is
application.
covered. This second